According to the Constitutional Court, in 2018, the use, possession, and cultivation of cannabis, or dagga, or weed, as it's commonly referred to, is legal for personal and medical use. But why is selling and buying cannabis products illegal if hemp is legal? Aren't they the same thing? The answer, of course, is no, not according to the law. In October 2021, the minister declared that hemp is an agricultural product which can be propagated, exported, and cultivated with a valid, untransferable permit. So why can we cultivate, propagate, and export the one, but not the other? The large part of the answer lies within plant breeders' rights. So what are plant breeders' rights? This separate protection for new plant varieties exists because new plant varieties cannot be patented as an invention, but they still require protection. A sui generis legal protection was created granting plant breeders' rights in terms of the Plant Breeders' Rights Act, number 15 of 1976. In terms of the Plant Breeders' Rights Act of 1976, or the PBRA, protection may be obtained in respect of a new, distinct, uniform, and stable variety of any prescribed kind of plant. Keep in mind the term prescribed. If the requirements for protection within the Act are met and the plant variety is registered in terms of the Act, then the plant breeder who now holds those PBR rights is accorded certain exclusive rights in respect of that new plant variety. These rights include the right to production, reproduction, sale, exporting, importing, and propagating of that plant variety, all of which, of course, have commercial value. The only catch being that in South Africa, only those plants listed in a specific table of the regulation can be protected in this way. Thus, amendments like the one regarding hemp products widen the categories of plants that could be protected. Unfortunately, these new plant varieties take a long time to actually be added. So, marijuana, as it's referred to, and hemp might be different names for cannabis, or cannabis from the Cannabisae family, or Cannabis sativa, flowering heads, but the reason for their separate classification lies in the concentration of THC in the product. The new regulations maintain that hemp, plants or plant parts contain low levels of THC, about 0.2%, and anything above that within that categorization, and accordingly doesn't reserve protection. This is why a breeder can legally grow the one, but not the other. Once a breeder has a new variety they want to register, a specimen of this variety must be given to the Department of Agriculture or Land Reform and Rural Development, who will grow and assess the viability of the new variety. The viability thereof depends on the DUS standard being met. The D is the new variety distinct? In other words, does it look different from other varieties? The U are the characteristic features of the variety sufficiently uniform? This does not mean absolute uniformity, but rather that different samples exhibit the same characteristic features simultaneously. And finally, the S is for stability, meaning the variety must be stable throughout multiple cycles of growing within a controlled environment. It doesn't help if only one generation of the variety can be cultivated. Once all of these requirements are met, can a new variety successfully be registered? Once you have successfully registered your plant variety, do not use the name you want to use commercially as the denomination in the application. So, in conclusion, plant breeders' rights afford protection of biological material not afforded by patents. But there are requirements that need to be met for this protection to be afforded. Once all these requirements are met, and the variety is one which is afforded protection by the regulations to the Plant Breeders' Rights Act, then no one may grow that variety without a license by the breeder.